who've been attending these webinars day in, day out. We won't take any further time. Straight away switch over to Devang bhai. Devang bhai, I'll
Thank
just do
you.
a screen share with your slide.
Okay. Okay, fine. You go ahead. I'll then start.
Yeah. Yes.
Thank you. So, good afternoon, everyone, and I hope everybody and their families and their loved ones are safe and sound at home, wherever you are. Thank you, Parth, for giving me this opportunity, and also the two bar associations and their office bearers and everyone who's associated with organizing these webinars. I think it's a wonderful use of these unique circumstances that all of us are facing. So that we remain in touch with our profession, with our business, and also, as is the norm of the day, we learn something new by sharing it with each other. Uh, Law is a vast field, as you all know. Law has different aspects. Uh, I have chosen a topic to speak today to all of you under the Arbitration and Conciliation Act of India, which, as you know, is gaining great importance in commercial world, in the field of industry and business. And perhaps as we have experienced during this pandemic, uh, the importance of video conferencing, Zoom, and various other technological advances, which have helped us during these times where otherwise a lot of business would have stalled, is already stalled, but still whatever little we are able to do, it is because of these technological aspects. Now, as you know, that the Supreme Court of India, the High Court of Gujarat, and various other high courts around the country have been trying to operate at a very bare minimum level through video conferencing, and some very, very extremely urgent matters, largely criminal or where liberty of the person or the individual is involved. Those matters are being conducted, but they are far and few amongst the ones. And we need, we wished, all of us, lawyers, businessmen, clients, litigants, we wish that we could have worked at more capacity. One of the major reasons is the unfamiliarity of lawyers and litigants and even the courts with these technological advances to use it. And also, the second issue is for poor litigants, for ordinary citizens, for common man to have the cost of scanning and uploading and having a technological means at their hands. So perhaps if more of the commercial cases in the future were to go to arbitration, a lot of arbitrations would be of commercial nature, where the litigants and the lawyers and the arbitrators are all technologically advanced. They have the means and resources to use this technology. And perhaps if this was in place where arbitrations could still be conducted through this virtual means, then perhaps today in situations like this, we could have done a lot more work, and a lot of the more cases would have been, there would have been less load on the courts, it would have gone to arbitration, and those matters would have been conducted even during pandemic. So this is one advantage of arbitration that I saw, that had we adopted it a little earlier, perhaps we could have been in a better position, but better late than sorry. So maybe we can learn from this. But coming to today's topic, the Arbitration Act, as with any act in law, is too huge. So I am largely going to focus on the amendments that have taken place since 2015 by the amending Act of Arbitration, Arbitration Act in 2015, largely due to the recommendations of the Law Commission headed by Justice A.P. Shah, former Chief Justice of Madras and Delhi High Court, originally a judge of the Mumbai High Court. So Justice Shah Commission's report, which led to the 2015 amending Act of the Arbitration Act 1996, is what I'm largely going to focus on. And also the 2019 amending Act, which is the result of another fantastic judge heading a commission and making recommendations, that is Justice B.N. Srikrishna, former judge of the Supreme Court. The Srikrishna Commission recommended many recommendations, and on basis of which the Arbitration Act was amended in 2019. Of course, as I will talk about it, regrettably, some of his recommendations have not been captured by the amending Act, and some of them have been captured in perhaps not the correct way, which has led to certain creases being cropped up. We hope that judicial decisions over the time will either iron out those creases, or in its wisdom, the legislature will correct them by bringing out suitable legislative amendments. I will cover some interesting issues in international arbitration that have arisen through my personal experience over this times that I have practiced international arbitration. And then I will probably, after 45, 50 minutes, I will leave the rest of the time for your question and answers, so that areas or topics or other issues which I may not have covered, or which somebody needs a clarification, wants to discuss something, or has any queries, I'll be very happy to answer. I will first start talking on the key features that were made in 2015. See, India's arbitration regime has had, I would say, a zigzag progress. So it's a crab. If you take the analogy of a crab, a karachla, so it's moved like a crab. Sometimes it's gone forwards, then it's gone backwards, and then most of the times it has gone sideways till we come to the 2015 Act. So, for example, the pre-2000, the Renu Sagar judgments, both on the first Renu Sagar judgment, which said that if a party was subject to an arbitration agreement under a contract, but then instead of initiating arbitration for a dispute, went ahead and filed a suit, then that party, and if the other side, the defendant, came and filed its appearance, filed its defense statement, and did not file an application of either Section 8 or 45, then the whole abandonment process was complete, and then the party who first approached the court instead of going to arbitration is then precluded for all times to come for that dispute or that contract to go to arbitration. That was what Renu Sagar first held. The second Renu Sagar judgment, nothing to do with the first judgment, clearly went on a totally different track, and very importantly held an important landmark, that the scope of public policy for the challenge of a foreign arbitration award was quite limited and not very broad. So it went ahead and in its vision said something which led to the Shah Commission's recommendation, even Justice Sri Krishna's recommendation, and later Supreme Court judgments, which have now laid down the law that when you challenge an arbitration award in the court, and especially a foreign arbitration award, it can be challenged on very limited grounds. One of the grounds being that the award is against the public policy of India, that is against any law of India, but that too, it must be such that it shocks the judicial conscience of the court. It is such which is against public order and morality. Only then in those circumstances would the court interfere and strike down the award. So Renu Sagar in pre-2000, that was ahead of its time and saw in its vision what could be the law. Then, of course, we had 2 or 3 judgments which put us back. For example, the Bhatia case, we had the saw pipes case. All those judgments put the clock back. They went really back. For example, Bhatia held that a person can't be remediless. You have to have recourse. So without there being provision in the Act, all foreign arbitrations were made subject to Part 1 provisions, including Section 9 and the gamut of it. So that was a big change, and the Bhatia regime continued until the Balco judgment set it right. And Balco then said that Bhatia ends here. But then Balco created another controversy, because then what happened when so let me just, for those who are not lawyers and do not know the nuances of arbitration, you have under the arbitration regime a Section 9 for interim relief or interim measures, as we call it, injunction. So suppose you want some property, some subject matter of arbitration to be, some right to be protected till we go to arbitration and a full-fledged arbitral tribunal is appointed. Till in the interim, you could approach a court of appropriate jurisdiction for an interim measure. Now, Section 9 occurs in the Arbitration Act in what is known as Part 1. There are 2 parts, Part 1 and Part 2 under the Arbitration Act. Part 1 applies to domestic arbitrations and Part 2 applies to international arbitrations. So when you see Section 9, it occurs in Part 1, and the original Act as it stood, unfortunately, did not say that it would apply specifically to foreign arbitrations. So what do you mean by a foreign or an international commercial arbitration under the Act? So I'm perhaps getting ahead of my time. I should explain that. Whenever there is an arbitration dispute between one party, which is an Indian party, and another party, which is not an Indian party, but a foreign party, then such an arbitration is called an international arbitration or international commercial arbitration or a foreign arbitration. So in case of such an arbitration, you could still approach Section 9 is what is now brought in by the 2015 Amending Act. And Section 9 specifically now has a proviso that there is a section itself which says that Section 9 is made applicable to international commercial arbitrations. The resultant effect is that now even in internationally commercial arbitrations, a party can approach an Indian court and seek interim measure till the tribunal is constituted and is able to hear application under 17 or take other remedial steps that are there. So that is one of the key features of the 2015 amendment, Section 9 being made applicable to international arbitrations. Section 37, the provision for filing appeals in a court against arbitration awards or certain acts of the arbitral tribunal. There are also two sections of the arbitration arbitral tribunal's powers to either permit you to raise a jurisdictional issue or to raise an objection to the constitution of the tribunal itself, or to say that the arbitration is beyond the scope of the dispute, the arbitration clause or arbitration agreement, or the validity of the arbitration agreement. That has been made subject to an appeal, and that also applies to international commercial arbitrations, even though one of the parties may be a non-Indian party. This, of course, is all subject to the seat of the arbitration, which I'll come a little later in my talk, because that changes the jurisdiction of the courts, which court would have jurisdiction. And that is still, I think, an unending dispute in the arbitration law. Then we had important amendment to Section 11, which is the power of the courts to appoint arbitrators or refer parties to arbitration. Suppose you have an arbitration agreement with another party and you arrive at a dispute and you want to settle it through arbitration, and you give a notice for arbitration and appoint an arbitrator. But for whatever reason, the other party refuses to agree to that appointment or doesn't respond to it, then your remedy is to file an application under Section 11, technically to the Chief Justice of the concerned High Court, or in case of an international commercial arbitration, the Honorable Supreme Court, who would have normally by himself or his appointed designate judge, who would be called the arbitration court or the arbitration judge, would then take up those matters and go ahead and appoint the arbitrator. That power, for a long time by judicial decisions, was held to be a judicial power. And that has been changed, and an amendment has been brought, and it has been called a designated power of the Chief Justice, so that no intra-court appeals are also maintainable against such an order. And the limit of that power has also been specified now by the statutory amendment, where the Act itself says that the power or the scope of the power of 11(6) of the High Court or the Supreme Court, as the case may be, is limited to the examination whether a valid arbitration agreement exists. If it exists, then it must refer the dispute to arbitration, the parties to arbitration, and appoint the arbitrator. It need not go into the merits of the matter. It need not comment upon jurisdiction of the tribunal, what is within the scope or not within the scope. That is not to be examined by the court under 11. That is to only be examined by the tribunal itself because of Section 16, which principle we have now famously coined as competence, or the competence of the tribunal itself to rule on its own jurisdiction, as it is with any court. If you go to a court, the court will rule on its jurisdiction, either on the objection of a party or suo motu, that I don't have jurisdiction or I have jurisdiction. The same way, the arbitral tribunal is at complete freedom to decide its own jurisdiction. And because of that, the powers under 11 of the High Court or the Supreme Court are restricted now to examine only the validity and existence of an arbitration agreement. And if it exists, then it has nothing to do else but simply to refer the parties to arbitration and appoint the tribunal in accordance with the Act. So that is a very, very important amendment that has taken place under Section 11, and I think that will go a long way in solving a lot of issues and a lot of litigations that has otherwise cropped up within our courts because of courts of various natures misreading 11 and going into disputes where it should not, and then protracted litigation, and sometimes destroying the very purpose of a fast remedial action of arbitration. What is, however, interesting is when I will speak about the 2019 amendments and section 11 subsection 9, where in case of a international commercial arbitration, if you were to file an application before the Supreme Court for appointment of a third arbitrator, that is in case you have a panel of arbitral tribunal that needs to be constituted in an international commercial arbitration, if each party has nominated its own arbitrator but have failed to agree on the name of a third arbitrator, then you go to court for the appointment of the third arbitrator, say under 11.9, and the Supreme Court, if one party, say for example illustratively is Indian and the other is say Singaporean, so then you have to have a third arbitrator who is neither from India nor a national of Singapore. He has to be a neutral, as we call quote unquote arbitrator. So necessarily a foreign personality. The problem then arises is that when I'll talk about the 8th schedule lays down the qualification of the arbitrators that the Supreme Court can appoint. Unfortunately, that does not provide for a foreign national being appointed, because essentially it talks of advocates under the Advocates Act, judges, retired or otherwise. They talk of chartered accountants, cost accountants. They talk about members of the industry and chambers of commerce. But unfortunately, they do not talk about a non-Indian citizen as qualified therein. So this is going to be quite a quandrum when it comes to that, because the Supreme Court will have to appoint a personality from a neutral country, and obviously that person will not be qualified under the qualifications laid under the 8th schedule. So some ironing out again will be required by judicial authorities, and this is one of the major lacunas or misreading of Justice Sri Krishna's recommendations while amending the 2019 act that took place. So it's a very interesting challenge that lies ahead, and I think it will be settled sooner than later by the Supreme Court or one of the high courts, we hope at its earliest. Then we come to section 16, the all important, as I touched upon it. It is the competence principle that is now very well accepted, that the tribunal has its own powers. It will be able to decide on all matters, including its own jurisdiction, and whether a particular subject matter forms the part of the as we call its scope or not. And it lays down as to when a party can raise such a plea or not. But at the end of the day, Parth, can we change the slide? Or you can actually not worry about the slide, because I'm not really speaking from the slide, so you can remove it also. It's okay. So coming to section 16, the tribunal has its own powers. Now here an interesting, in fact, I was just when Parth talked to me about a week back to speak on this topic, and we were discussing the arbitration law. We were discussing topics first of all, and then we arrived at a consensus that we should speak on arbitration law. And while discussing that topic with him, he said that, and I was a little bit aware of it in court that it was going on. So he told me that a very interesting case arose before the Honorable Gujarat High Court, where Parth himself was appearing for one of the parties, if I'm not mistaken. And it was an international arbitration, though seated in India, I presume. And one of the parties raised an objection to jurisdiction of the tribunal and whether the arbitration is maintainable at all or not. And the party raised it before the arbitration tribunal. The arbitration tribunal heard the parties on that and then said that, okay, we will consider this. We still believe that there is a prima facie jurisdiction available with us. So we'll deal with it. The reasons for our proceeding ahead, we will give later on with the final award. At this stage, the party that was aggrieved by this, since this was not an appealable order clearly, and because only 37(2) and 3 applied to international arbitrations, that is the appeal provision, section 37, they filed a petition under Article 226 of the Constitution of India before the Gujarat High Court and challenged this order of the tribunal there. Because of the peculiar conundrum that has arisen, that obviously if High Courts and Supreme Court under 226 and 32 started interfering in arbitration proceedings, there would be no end to it, and it would be a major issue. So therefore, under these circumstances, the High Court, I have been told, and though I have received a copy of the judgment, I haven't gone through it in great detail, has essentially rejected the petition, saying it has no jurisdiction to entertain such a petition. I have a issue with it, and I hope at some stage we are able to clarify. Because if a serious jurisdictional challenge is maintained by a party under 16 before the tribunal, and if the tribunal doesn't decide it preliminarily, because it has to give a partial award, once it decides to hear the preliminary objection or jurisdiction application first, then it must pronounce a partial award. That is the procedure followed in all international arbitrational institutions. For example, an ICC arbitration, that's the International Chamber of Commerce, the LCIA, the London Court of International Arbitration, or the SIAC, which is the Singapore International Arbitration Center. All of these have a laid down procedure where if a jurisdictional or a preliminary objection is taken, akin to our Order 14, Rule 2 of the Civil Procedure Code, then such an application would be decided first. Of course, while deciding that application, in order to decide a jurisdictional issue, if the tribunal is of the view, like our courts, that evidence will be required, evidence will have to be led, then it will go ahead and apply the tests of 711 or section 482, that you take the plaint or the complaint as the gospel truth. And even then, if I don't have jurisdiction, then that's the end of the matter. But if evidence is required, obviously they will reject it at that stage and go into full trial. But if they otherwise reject it or accept it, then a partial award must be entered, so the party aggrieved by it has a right to challenge it. Because imagine that today, if the tribunal has no jurisdiction, no proper jurisdiction, and if they say that, okay, we've heard you on it, you raised the objection, we've heard you, but we will decide all issues and pronounce award accordingly, then the whole gamut of the entire process of arbitration, evidence, costs relating to that will have to be gone into. And eventually, it will take a lot of effort then to challenge such an award on the limited ground of jurisdiction. Here, parties are very clear that you raise a preliminary issue, you pass a partial award, and it is not prejudicial to the party who is the defending party for that, because it will be awarded costs in case such an application is found frivolous. And such an application may not require a full-fledged longest hearing. So some way will have to be found out. Because of this, according to me, what is again a legislative loophole that exists, that your 37 challenge is not available for a preliminary issue raised or a preliminary objection and jurisdiction raised before the tribunal. So perhaps one of our Supreme Court judgments or the legislative wisdom will prevail, and it will hopefully iron out this crease which also remains. But thank you, Parth, for pointing out this judgment, because for me it's while the judgment in law is correct that 226 should not be usually an answer to interference in arbitration tribunals or awards, but what does a party do? Easy remediless, because you've raised the preliminary objection, and what I heard from you correctly, they heard it. They heard the objections and the arguments, and they've simply said that after hearing, we feel that, oh, prima facie, it looks like we have jurisdiction, we'll decide it along with all. I do not think that this, perhaps the consequence of that is the correct thing. A partial award should have been passed. That brings us to, very interestingly, the 2019 amendment on section 19, which is the awards section. I'm sorry, not section 19. It is after that. It will come somewhere, section 30. I'll just give you the. Anyways, so the definition of awards includes an interim award, section 2, but it does not include an emergency award. There is no provision for an emergency award. In all other arbitration regimes, including the institutional arbitration regimes that I mentioned, they have a provision for appointment of an emergency arbitrator and an emergency award. That will reduce the burdens on of our courts for section 9 and other long out processes. So emergency arbitrators and emergency awards are basically meant to sustain the party or to protect something which otherwise will go into a irreversible situation, irreparable loss, to maintain the balance of convenience. These emergency provisions are there which will survive till a full-fledged arbitration tribunal is constituted, full pleadings are in place, and the proceedings can proceed. So in case the word as itself suggests, in emergency, say a situation which we are facing today, in such a situation, if the tribunal is unable to be constituted, there is no possibility of a hearing being conducted or some emergency arising, then at least there is a provision. Unfortunately, the 2019 Act, amending Act, though having the benefit of Justice Sri Krishna's wisdom, who himself is a very well acclaimed international arbitration expert and has been a judge and on the body of many international arbitration bodies, his recommendation for including an emergency award and an emergency arbitrator provision, it doesn't find mention in our act. So that is another lacuna which remains. However, then section 17 is another provision which provides for the powers of the arbitral tribunal to grant interim measures to protect, just as the court has under section 9. The tribunal has all the powers under section 17. Basically, they are coextensive, if we use the words, with the powers of the court under section 9. However, with an important amendment which removes a long-standing confusion which existed. So the original 17 said that the tribunal's powers under 17 continue till an award is executed under section 36. Actually, the tribunal becomes functus officio once it signs the award. Just like a court, once it signs the order, it becomes functus officio. Here also, the tribunal, once it signs the award, it becomes functus officio. But because of the wordings used in the earlier section, that it continued till the award was entered into under section 36, there was a lot of confusion as to, because there were instances where the tribunal started, passing awards after it had, passing directions after it had passed an award and the award was already signed and done. This was changed and it included now the tribunal's power to pass interim measures and directions limited only to its exist till it passed the final award. Once it had done so, it goes. So that is another good provision that has come in. The interesting part, very strangely, because as you know that arbitral tribunals and arbitration process is supposed to speed up the judicial process, to speed up commercial disputes and decide them quickly without the long wait which otherwise we have in courts and especially in India, and make it less cumbersome for commercial parties, for businessmen to effectively, efficaciously and speedily resolve their disputes. So the 2015 Act brought in, for the first time under the Indian arbitration regime, time limits. And we were all very happy. Under the 2015 Amending Act, there was a time limit of 1 year for completion of international commercial arbitrations. And there was a time limit of 6 months, extendable by another 6 months. So 1 year to complete domestic international arbitrations. Domestic arbitrations. Now, the interesting problem is that the 2019 Act brought in an amendment in section 29, which deals with the time limit for arbitral awards, and more so in section 23. First in section 23, that is statement of defense and claim. And there they added subsection 4 by the 2019 Act, which reads as under: the statement of claim and defense under this Act and under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, received notice in writing of their appointment. Essentially, it says that once you appoint or the arbitral tribunal is constituted, within 6 months, you have to complete your statement of claim, and the other side has to complete its statement of defense, that is pleadings in short. Now, unfortunately, Section 29A, which is the section imposing the time limit for the arbitral award, also now says that the award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of 23. So initially, before the 2019 Amendment Act, you had 1 year time limit consolidated, 6 months and 6 months extension. So 1 year to complete the entire process. Now the process would obviously include filing of a statement of a claim and a defense. And frankly, it doesn't require 6 months to file a statement of claim and defense. So you actually had only 1 year. Beyond that, you had to go to court to seek permission to extend the time limit. Now, automatically by 23.4 and reading of 29A, which is relatable to 23.4, it gives you 6 months more, so 1.5 years. Because first you have the 6 months to file the claim statement and defense statement, and then you have 1 year to complete it. So your time limit actually clock of 1 year starts running, 6 months or 1 year, extendable to 1 year, starts running from the end of 6 months under 23.4. So unfortunately, the 2019 Amending Act, which misreads the recommendation of the Sri Krishna Commission, has actually put the clock back, and now it has 1.5 years. I think I know this because somewhere I remember Justice Sri Krishna complaining that I will never accept an Indian seated arbitration because you have to complete your arbitration within of your appointment, and all these very good arbitrators are so busy that their dates simply are impossible to get if you complete an arbitration within 1 year, and they usually sit on very complicated and lengthy and high stake arbitrations. So somehow I think a little bit of personal views have got into either the recommendations, or the government has listened to too many arbitrators' complaints and given effect to, and in fact hurt the whole purpose of fast disposal. Anyways, so that is another interesting conundrum that exists in the new amending act that exists. Then, as I said, of course, in international arbitrations, the time limit is 1 year if it is governed by our Arbitration Act to complete it, if it's an India-seated arbitration. And then even in the Section 34 challenge, now the challenge has been made very limited. Even the public policy ground available for challenge, as I said initially, has been now limited to very, very severe, if I may use the word, infractions of public policy of India. That if it shocks the judicial conscience, if it is against public order or morality, and it really is not in consonance with India's constitutional or fundamental beliefs and basic structure and our laws, then only then will the courts strike the award down on grounds of public policy, otherwise not. So that is another interesting change which has occurred under the new 2019 Regime Act. So these are some of the key features which I have found. Of course, and one more interesting part before I forget. So as I was telling you, another thing that the 2019, both the 15 and 19 amendments missed is to lay down a model rule of procedure. So as you know, under Section 19, in domestic arbitrations, we are free, unless you have adopted a body like ICC or SIAC rules of procedure to apply by agreement. Parties are free to agree on any procedure, and the tribunal is then free to set out its own procedure for leading evidence, leading of conduct of the arbitration, and so on and so forth. No particular law like the CPC or the Evidence Act specifically governs it. The parties are free to do and choose. However, what was recommended in 2015 and 19 was to adopt the model rules of procedure from the UNCITRAL model or any the model rules of procedure, or ourselves draft a model rules of procedure and make them part of section 19. So like an institution, if you are India governed arbitration, then you are immediately governed by this model rule of procedure, which is uniform, succinct, and well tested. Unfortunately, such a provision doesn't form part of the 19 amendment, which otherwise should have been. What is very important and very positively done through the 19 amendment is the setting up of an arbitration council. An arbitration council is to be set up. Unfortunately, while this provision has become law, the council is not yet set up. The arbitration council will consist of a nominee of the Chief Justice of India, will consist of judges, both retired and present judges. It will consist of arbitrational practitioners. It will consist of experts of arbitration field. It will consist of professors of law or jurists or academicians. It will also consist a representative of the commerce and industry or trade or business. Unfortunately, as with everything in our country, it will also include 3 officers of the government to be nominated by the government. I have no idea as to what they will do and what is the purpose of having government officers sit on an arbitration council, save and except to say that government of India is one of the biggest litigators in the country, including in arbitrations. But of course, it is responsible for the litigation too, because as the legislative draftsman, the court goes that I am the one who drafts the laws of India, and I am the one responsible for half of its litigation, because it's the bad legislative drafting that leads to most of the litigation that we face. So very interestingly, that is a conundrum that exists. But otherwise, the setting up of an arbitration council is very important because it will grade arbitrators. It will create a panel of arbitrators, then grade them, give them marks that these are top quality arbitrators, these are B quality arbitrators, these are C quality arbitrators. So essentially, it will grade both arbitration institutions and arbitrators. It will lay down qualifications for them. It will lay down trainings for judges, for retired judges, for lawyers. It will eventually go to the dream which we should have as an arbitrational friendly country. And if we want to make India an international commercial arbitration hub, which it should be rightfully, considering our position in the World Economic Forum, we should be an international commercial arbitration hub. But for that, we need a specialized arbitration bar. We need specialized judges who are trained in arbitration law, who have been trained. So this arbitration council's one of its objectives, purpose is also to do this. And we hope that it is set up at the earliest and performs its duties to the best. It also lays out, as I said, in the 8th schedule, the qualifications of arbitrators. And that is where the conundrum occurs. Unfortunately, the Arbitration Council also misses one important category and does not include in its composition any foreign expert. It is time that the Advocates Act is amended suitably to allow international arbitrational practitioners to at least appear in international arbitrations in India. If you want to make India an international commercial hub, and if you are not going to permit foreign lawyers to come and appear in international commercial arbitrations, India will never become a hub for international commercial arbitration. It is an irony that under Mr. Modi's leadership, one of his pet projects in Gujarat was the gift city, and which is doing very well. And all the leading financial institutions are there. And because of that, the Singapore International Arbitration Center has set up a center in gift city. It's a branch office kind of thing. But unfortunately, if it conducts arbitrations here, then international lawyers still can't appear. Of course, the last amendment that has been brought in is that because gift city is quote unquote an SEZ status, I think some amendment was brought in by the government of India to allow international lawyers to do work within the gift city. I don't know whether that has come or not. I may have to check and get back to you on that. But that is a lacuna which we need to fill up. We need international experts on such bodies as the Arbitration Council of India. We need them to be appearing in India, to be guiding us, because that's the only way India will become an international commercial arbitration hub. without which it cannot be. And if need be, we should not be shy to amend the Advocates Act to allow this, because it's the norm, it's the requirement of the day. So that is a very thing. Another interesting thing is that one recommendation of Justice Sri Krishna, which the 2019 Amending Act did not accept or has not incorporated within its ambit, is the amendment in relation to, it had asked for setting up of a standing committee under the Arbitration Council. This standing committee would exclusively consist of arbitrators, arbitrator practitioners, that is lawyers, and judges and retired judges, who would then make recommendations with changing time. Suppose today they find that this provision needs to be amended, this provision needs to be added, this provision needs to be removed, then they would make these recommendations directly to the legislature and not wait for courts to clarify. Because usually we wait for the judicial process to clarify a lacuna in the legislative drafting. We wait for a court judgment, a Supreme Court or a High Court judgment to come us and guide us, or fill up that gap or iron out that crease which exists in legislative drafting. That was sought to be removed, and that takes years. That process takes years. As you know, Hardy's case, Hardy case came, then it was referred to a larger bench, 5 judges. Now 2 judges have tried to explain BG's case, what is Hardy's case, and virtually set it aside. So judicial process has its own problems and takes its own time. So this standing committee, which would consist of judges and lawyers and arbitrators, would then recommend directly to the legislature to bring in emergency amendments so as to immediately solve the problem that exists. So that, unfortunately, recommendation of the Sri Krishna Commission has not been accepted in the 2019 Act. Section 34 and 36 have been amended suitably to say that there will be no automatic stay of the arbitration award, which used to be the norm, which is very important. So first, if you had an award and you challenged it, there was an automatic stay of the award, and the process went into our judicial process, which took years to clear. Now there will be no automatic stay. Of course, the irony is that they have used the words, they have not used that they will apply retrospectively. Of course, because, these provisions and amendments which have been brought into, so we must distinguish the 2 parts. One is the arbitration proceedings pending before the courts, and the other is the arbitration proceedings pending before the arbitration tribunals. One agrees that all the new amendments will not apply to arbitration proceedings pending before the tribunals, because those had begun when the law was different. So they will continue to be governed by the old law. However, as far as the proceedings in court are concerned, a proceeding like Section 36, where there is no automatic stay of the arbitration award, cannot apply only prospectively, it must apply retrospectively, and all pending matters must be governed by 34 and 36. The public policy argument, the limits and the scope of the challenge of 34, if you do not apply to existing matters, if you do not apply to appeals which are already pending before the courts, then there is no purpose in this. We hope that the courts, however, of course, have been doing it, and we hope that the courts continue to apply these amendments to proceedings which are pending before them, which is the right approach, which is the correct position of law, and which the Supreme Court has also done day in and day out. So we hope that it will but this lacuna again was left in the 2019. The second was the amendment of Section 45. As you know, it's a parallel of Section 8. In international commercial arbitrations, the power of a judicial authority to refer a party to arbitration exists under Section 45. And there also, what the court has to see is the valid existence and validity of an arbitration agreement, and a prima facie view that the dispute brought before it falls under that arbitration agreement. And then it can refer the party under Section 45 to arbitration. Unfortunately, the prima facie case, as the original Supreme Court judgment, Justice Dharmadhikari's judgment in Shinetsu, was that prima facie case was to be seen if you were not going to refer a party to, if you're going to refer a party to arbitration. If you decided that you are not going to refer to it, then fine, the matter ends. However, unfortunately, the word prima facie in the new amended section 45 precedes that court must first examine that there is a prima facie case and then refer a party. So essentially, you have brought in the reverse. It's a regression because you brought in the reverse. In every case, the court will have to first see the prima facie case and then decide whether to refer it or not. Otherwise, what the judgment of the Supreme Court was that you first decide whether you're going to refer it or not. If you're not going to refer it, then the matter ends. Only if you're going to refer it, you see the prima facie case. Unfortunately, this position has been reversed, and the draftsman or the legislative intent has been totally lost. The draftsman has lost it. As somebody rightly said, words are but mere vehicles of thought. And it is, a person usually struggles, as I am right now, to put words to my thoughts, and as most of us do. However, where it becomes even more difficult when you are trying to put words to the thoughts of somebody else. In this case, the legislature's thoughts are being put to words by a draftsman. So there is going to be difficulty, and more difficulties arise when the explanation to this, whether the legislature meant this or that, is to be interpreted by even another third party, that is the courts. And that is the conundrum that we all survive, and that is perhaps some of us have some work, I guess, because of this confusion on a lighter side, absolute lighter side. But so these are the problems that arise under the 2019 Act. So having completed the 15 and 19 overview of amendments, and most of it what has been left out rather than what has been put in, I will just raise a couple of issues that in my short experience as an arbitrational practitioner I have faced, especially in two international commercial arbitrations cases that I have had. Of course, I am not at both the cases are currently quote unquote still under process. So I will not be able to use any party names or give you any references of the case law, the judgments, etc., or the awards. I will only use their facts and the points of law that arise. Of course, I wanted to cite three. One I already cited earlier, that is Parth's case, because I found it very interesting, and it will be interesting to see whether this point of law, how it develops in the future. But the other two is, one relates to, actually 2 points arise in one case. One relates to seat, the law of the seat, and the other relates to what I would call is abandonment of an arbitration agreement. That is one case. And the other case, it relates to a very interesting position. And this, I'll take the other case first, because I think it's the most interesting one. It's in fact, we are in the process. I was told that my good friend and colleague, Nakul Devang, who is much more of an arbitrational expert than I am, is also part of the audience somewhere. And I think he's going to speak there tomorrow on some other subject also in your webinar. So Nakul is in fact, because that matter is in Delhi High Court, and so Nakul and I are doing it together. And a very interesting question arises there is that two Indian parties, the dispute involves two Indian parties. Both of them are registered companies in India. Both of them entered into a contract to be performed in India. So everything was closest connection, or all connections with India. They chose the venue of arbitration to be London. And not only that, they chose that the procedural arbitrational institution governing the arbitration would be the International Cotton Association. And if we see the bylaws of the International Cotton Association, which they have chosen as the procedural body of to govern the arbitration, it specifies that irrespective of what the parties have written or done, if you choose the International Cotton Association, then the laws of England would not only govern the arbitration, but would also govern the interpretation and the dispute of the substantive contract. Now, as you know, under arbitration law, there are three laws which apply. The first is what we call the substantive law. That is the law that governs the contract itself. The second we call the curial law, or the law that governs the arbitration agreement. So suppose if you use the words the arbitration agreement shall be governed by the Arbitration and Conciliation Act 1996. So that means Indian law would govern even the arbitration agreement. And the third is the lex arbitrae, where the law of the seat governs the law of arbitration. So if you have chosen London to be the seat of arbitration, then automatically the laws of England would govern the procedural part of arbitration, the lex arbitrae as we call it. So it's a very interesting dichotomy of these three laws apply. Here in this case, parties chose Indian laws to apply. The parties are from India. The parties have to perform the contract in India. There is no foreign element involved except referring the dispute in London to take place in London and to be governed by the Indian Cotton Association, which says that no, if you choose us, then we will only decide the dispute under English law. It's a matter of Indian public policy and Indian judgments that two Indian parties cannot choose to give their dispute decided by a foreign court or a foreign law. So suppose, two parties cannot choose to grant jurisdiction in contradiction to Indian law because both of them are governed under Indian law. So this matter raises very, very interesting questions. In a somewhat similar case, the Supreme Court had said that, of course, there one of the parties was virtually a dummy. The real correspondence and business and including the performance of the contract was done abroad with its wholly owned parent company. So there the Supreme Court said, well, you've chosen England, you go to England, let English laws govern you. But that is, of course, on a very separate facts. These facts are very interesting. The matter is being moved in near times before the Delhi High Court, and we'll soon have some light as to at least what the Delhi High Court thinks about this proposition. So this, I thought, is a very interesting conundrum, and that's why the importance. That brings me to the second small part of my heading of the topic, which I had said, drafting arbitration agreements. So when you draft arbitration agreements, and I noticed that the income tax bar and the sales tax bar and a lot of the taxation bar members are involved here. In some of the legal officers of the client, litigants are also involved here in this webinar. And it is my advice, though please don't misunderstand me as some sort of marketing tool on my behalf or any of my legal fraternity members, but please draft an arbitration agreement properly through a proper lawyer. Because if you miss the very, very nuanced differences between seat, place, venue, jurisdictional law, lex arbitrae, curial law, substantive law, you will pay a heavy price when you actually get into a dispute. There have been major disputes of great stake, of great values, unfortunately going for a toss because people have not understood the ramifications of properly drafting an arbitration agreement clause. So please, when you draft an arbitration agreement, don't cut, copy, paste from somewhere that you find on the internet or Google or whatever that you look for, kanun.org or whatever that there exists. Please go to a proper arbitrational practitioner or a proper lawyer with basic knowledge about the arbitration law, who will then be able to guide you and explain to you. Or when you are signed, sometimes you have to sign on dotted lines. When you are doing business internationally and you receive an arbitration clause, please make sure that you properly understand the impact of jurisdiction, the impact of curial law, the impact of seat, the impact of place, the impact of venue. So, and there is, unfortunately, despite this being an issue in so many arbitration disputes around the world, the law still vacillates and oscillates. There are judgments which say one way, there are judgments which have taken the other view. Courts in England through the Sashua case and the Sular America case have taken a different view. Courts in India through our own Sashua case and Enricon and other cases have taken a totally diametrically different view. And it's not a simple proposition. So please make sure that you understand as to what jurisdiction you are submitting. The challenge procedures are quite different. As I am learning to my detriment, a challenge before an English court of an award, including a jurisdictional award, is quite different than what we would have had in India. Surprisingly, the English challenge is much broader than our challenge under our amended act in India. So these are very interesting and challenging perspectives which one must keep in mind while one drafts an arbitration clause. So this is one interesting example that I wanted to point out to you. The second interesting example that I encountered during my experience in international arbitration was this very proposition, that though the parties to contract had specified that the agreement would be governed, the substantive law would be Indian law, the law arbitration agreement would be Indian law, the seat was England, that this was all agreed. So the lex arbitri would be English, but the seat law would be English, but the lex arbitri was Indian. Even under these circumstances, an issue arose whether an intellectual property right or an infringement of an intellectual property right could be arbitrable under the arbitration, subject to arbitration. Because as you know, an intellectual property infringement involves elements of both a right in rem and a right in personam. If it was restricted to a right in personam, that is between the parties, then obviously it's arbitrable. However, if it involved rights of rem, that is rights of people other than those who are parties, then obviously it's not arbitrable. In India, series of judgments have taken both views, with the Supreme Court's judgment in Ayaswamy in one line holding that intellectual properties disputes are not arbitrable because because you could file a challenge of validity in case of a patent or a annulment of a trademark. In such cases, then those would be affecting rights of rem, because if a patent is invalidated or a trademark is set aside, then it is set aside qua the world, it's qua the whole world, and so it becomes a remedy in rem or a right in rem, and therefore not arbitrable. So in the Indian law took one view. The English law is much more liberal. It allows arbitrations as long as they don't they need to decide anything that is in rem, and it's only if personal infringement, then they can decide. Both the parties, that is the party raising this objection and the party defending it, did not want to apply the law of the seat to it. They both they filed their pleadings under Indian law and restricted their arguments to Indian law. During the hearing, the tribunal comes up and so moto asks that, oh, we feel that the law of the seat should govern this point, because this is the arbitrability issue, and that would be governed by the law of the seat. Though a catena of Indian and English decisions show that it's the law of the arbitration agreement which would govern this. But that's another surprise that you get when you have a internationally seated arbitration and you don't expect, and now suddenly English law is governing the arbitrability of issues. So the issue of arbitrability. So these are very, very, very challenging questions that come up out of a very simply what you feel is a very self-explanatory, clearly drafted arbitration clause, and yet you have this. One usual, sometimes you go through arbitration clauses and many lawyers don't pay attention, or many litigants don't pay attention, or corporates don't pay attention, that the arbitration agreement says est equa bono. Es equator bono means that you can decide on equity not strictly governed by the principles of law to do justice between the two parties. If this power has been reserved to the arbitrators, then the arbitrators are not bound by the principles of law strictly, and they can decide what is fair and justiceful between the parties. So you have to be very careful. If you want this, you should include this specifically. Because if it's not included, then the tribunal will be bound by the law which governs the dispute and will not be able to move out of the principles governing that law. For example, our courts in High Court also, they say they are courts of equity and they can do substantive justice. Yes, but they are still bound by a constitution and the limits of law that exist. Whereas if you give the ex equo bono power to the tribunal, then you move out of that, and the tribunal is virtually like a friend settling a dispute between two friends, a mediation, a conciliation, or our old panchayati system, not the new panchayati system, but the pre-British age panchayati system, where the panchayat got together practically because of custom and usage and what was acceptable to the elders of the village. The dispute got settled in that manner to do justice between the parties. So these are very interesting nuances which exist, which you must be very careful when you draft your agreements. So I think, Parth, I have reached the end of my slated 1 hour that I promised you to garble out whatever I could, what I've learned little bit of arbitration law till now. So I guess I'm open for questions, queries. I see a lot of them have come, but I leave it to you to select the ones which you
Devang bhai,
feel.
almost about 26 have come. We
Okay.
are, what I've done is I've tried and filtered them out to about 10 or 12 of them.
Okay.
And maybe we can just take them one by one.
Okay. Sure.
The first query is whether a quote mentioned in section 29A is the
Yes.
same as the quote defined in 21E of the Arbitration Act.
Yeah. So take it from me that once the definition, as you know, is the simple law of legislative drafting, that if the word used in the act is defined, unless the that provision of the act specifically says it is the same definition. So the court would be the principal court of civil jurisdiction or the high court exercising its original jurisdiction thereabouts. That's 2-1 whatever E. Yeah.
Another question is what will be the competent court, rather commercial court, to hear the arbitration cases here in Gujarat, because there has been a recent issue with respect to whether a senior civil judge or whether a small court judge can take these out.
I think that solution has not yet come forth fully. I think a representation was made by all of us, led by, I think, Mr. Mir Thakur, a very senior advocate. I think he spoke on the webinar on a different topic. So Mir Bhai had represented to the then Chief Justice, I think acting Chief Justice, Justice Dave. I think if I saw Justice Harsha Ben's name on the participants list, I think she was also probably there on the court when I think this representation was made to the senior judges also. I don't know whether the High Court has come to a conclusion and solved it. I was told that some sort of directions were being made ready to be passed to the civil courts so that they can appropriately correct them. But last my knowledge was that no, this issue has not yet been fully resolved. It's a sad thing, but it has not been resolved to my knowledge. But somebody can correct me if I don't have the latest information.
Then, if an application is not filed within the time period prescribed under 29A, would the mandate of the tribunal automatically stand vacated?
It should. But of course, then the question will come whether you could, inherent powers of the court to extend the time limit would also include the inherent powers of the court to kind of what you call, condone the delay. But I don't think till now we've had, but this being a statutory time limit, I don't think such a view will be taken by the court. So if you miss the boat, you miss the boat. The tribunal becomes functus officio and it terminates. Because if you see the termination section, this is one of the grounds of the termination, unless so extended.
Can a plea against a jurisdiction of a tribunal be taken up under section 16 when such tribunal has been constituted pursuant to orders passed by court under section 11?
You see, section 11 only appoints an arbitrator if an arbitration agreement exists. Whether that tribunal which comes into being is having jurisdiction to decide a matter, A, because of a legal infirmity, or because the subject matter of arbitration doesn't form the scope of the arbitration, all that is for the tribunal itself to decide its own jurisdiction. So just because the court has appointed an arbitrator under 11.6, no, the power of 16 remains unbridled. In fact, that is precisely the amendment under 11.6, that the High Court or the Supreme Court will not get into these matters, whether the tribunal has jurisdiction or doesn't have jurisdiction. So no, the answer would be a simpliciter no, that just because the court has appointed an arbitrator or arbitral tribunal, no, it doesn't get jurisdiction.
Is a section 9 application maintainable after a tribunal is constituted?
In certain cases, yes. For example, when it involves property disputes and suppose a third party who is otherwise not subject to arbitration cannot be joined in the arbitration, yet is somehow affected or required to be ordered against to protect or preserve the property or take the interim measure, then yes, the only remedy will be 9 because the court would have power to issue directions to a third party. Whereas under 17, the tribunal will not have a power to issue to a third party. So in certain circumstances, yes, I believe that 9 would be and they are coextensive. So court can always do it. Courts don't prefer to do it once tribunals are there, because then 17 is available. But if you can show reason that because of these reasons it's not possible for 17, it can only be done through a court, then yes, 9 would be maintainable.
Does the 2019 amendment to section 29A apply prospectively to new arbitration matters, or does it apply only to existing arbitrations?
So, as I said, that a view that is forthcoming right now, unless we get a clarificatory judgment of one of the courts, and especially the Supreme Court, any arbitral proceeding which are pending will not be governed by the amendments. Only so no 29A will apply to things which will begin after the date of that amendment and not before that.
There's one interesting question. It says, is it time we have a code for arbitrators which they are required to Sorry. Is it time we have a code for arbitrators which they are mandatorily required to follow?
So that is what the arbitration. So if you will see the and the purposes of the Arbitration Council, it's supposed to lay down guidelines. It is supposed to lay down training seminars for arbitrators. It's supposed to grade arbitrators, create an arbitration panel, and appoint arbitrators for them. Because you see, in an arbitration, parties are free to choose their arbitration. I can have, for all you know, a clerk in my office as an arbitrator between a dispute between me and somebody if the other party agrees. You know, there is no law which prevents two parties from agreeing to arbitration by any person who is necessarily so-called not qualified in the traditional practices of law or otherwise. So bringing in a code for arbitrators would be kind of difficult, but guidelines are set out in this, and the Arbitration Council precisely wants to do that. It wants to lay down standards. It wants to grade them. I mean, it will actually give you a grade, like you designate a senior advocate, or you say that you are qualified to practice this or not practice this, or you're qualified as a solicitor, or you're qualified to practice here. Or, as in the old days, we had qualifications to practice on the original side and the appellate side and pleader and non-pleaders and all that. So basically, it will grade arbitrators and the judges to put them in accordingly there. So some of these issues that you raise with the code are already covered under the Arbitration Councils.
We'll take the last question, Devang bhai. There are arbitration agreements with government PSUs, or for that matter, for any other two-party disputes, where there is a clause which says that the party who is in control, say for example, a chairman of one of the parties will have the unilateral power to appoint an arbitrator. How far would such a clause be valid?
So that would, I mean, such a clause would be valid provided the appointment of the arbitrator is in conformity with the qualifications of the arbitration in section 12, laid down in 12 of the Act, and the 5th schedule, which requires an arbitrator to disclose his relationship with the parties, and which is that in these relationships, you should avoid taking up the arbitration, and then the party who is aggrieved by such an appointment has a right to object. That because, so if the chairman of, say, a PSU, hypothetically, let's say the oil corporation, for just to illustratively give you an example, the chairman of IOC, we have this petrol pump arbitration disputes that are very common in India. So they appoint a manager of IOC to be the arbitrator. Then obvious under this new regime read with the 5th schedule that such an appointment would be, strikeable or would be bad in law.
Thank you, Devang bhai. We've had a fantastic session today. Thank you for sparing time for all of us. A big thank you to all the participants.
Parth,
Yes, Devang bhai, go ahead.
Sorry, so I said thank you, and I must seek apologies for I don't know how well I was able to do, because the vastness subject is so much, so I've tried to just live 15 and 19 amending acts. But later on, hopefully we'll open on May 3rd. Today's Prime Minister's conference says we may not. So if and we have more time, we can select one particular subject and then concentrate on it. But thank you very much to you, both the and to everyone who's involved in this, and to participants, of course, without whom we would be, we wouldn't get this opportunity to speak to all of you. So thank you all for sparing your time, and hope I've been able to give you some useful nuances about the arbitration law.
Thank you, Devang bhai. We've had a
Thank you,
fantastic
sir.
session today.
Thank you, sir.
A big thank you to Dhruven bhai, Vishwesh bhai, Kulin bhai, and Molin bhai for being here. We have a day 6 of our webinar series tomorrow. We have Senior Advocate Mr. S.V. Raju, who will be taking us through the topic of arrests and prosecution in tax and GST matters. I'm sure it will be of extreme interest to all the members of the associations that are conducting these seminars jointly with us. So see you all tomorrow 4 p.m. For the session with Mr. Raju. Thank you so much. Have a nice day.
Thank you, Parth.
Thank you.
Thank you, sir.